Hello, today I will be doing a brief training video on courtroom testimony preparation. There are three phases to testimony. The first is going to be voir dire, and that one is basically the preliminary screening of the expert to determine what qualifications, expertise, education, training, further knowledge they may have. The second phase includes the direct examination with the attorney that requested you as an expert. This is where the expert walks through the process of any examinations, analysis, or tests that they did conduct or perform. This might be where you may make a visual aid and present it. And this could be a poster, video, infograph, anything that will help the jury or the judge understand the topic a little bit more. Sometimes it's easier to explain with photos than it is with just words. Um, they will also help relay their findings and any interpretations they made to be able to reach a certain conclusion on the results of any of the tests that were conducted. During the third phase, this is going to be where cross-examination occurs. This is going to be where the opposing counsel or attorney has the ability to question you as an expert. This can be anywhere from your credibility to your work to your findings to the reports that you made or any of the science behind your testimony. They are even able to question you as a person or expert. This can be anywhere from where you went to school, anything that has happened in your past life. This can be a deep dive on your personal life. Everything is open to be brought up during trial. It is also very important in this phase for the expert to learn when to answer a question. Sometimes knowing when to answer and when not to answer is important, and it can actually help you in a testimony. Most of the time, there will either be communication with the attorney, or there is also times where there is no communication with the attorney prior to trial. In either situation, it is important to know how to prepare. In the first scenario, where there has been communication with the attorney prior to trial, the expert is going to be aware of what evidence, what reports, what tests are going to be called to be further discussed. This will allow the expert to review the reports, the tests, or any of the work that they had conducted. This will also allow them to refresh their memory and try to remind themselves what they did during this time. Um, this will also allow them to research the topic if they're a little bit not refreshed on the topic as they should be. This gives them time to look up or research anything they may need to for the testimony. This will also help them provide a more credible testimony, which is something we always want. Additionally, it allows the expert to focus on topics that are going to be discussed instead of subtopics that may not be as important in the case. For example, if they're talking about blood, sometimes they want to focus on the DNA instead of blood spatter and how those patterns occur. Furthermore, the expert will know the attorney's goal during that testimony, which is important to note that the expert is not to testify on if the evidence can determine innocence or guilt, but that is for the attorney to do. Although they might try to ask leading questions or try to insinuate things during the testimony, they will ask those types of questions. Um, In the second scenario, where there hasn't actually been any communication with the attorney that requested your expertise, the expert has to actually spend more time preparing, reviewing, researching any of the topics that were involved with the case that may be all of the notes, all the reports, all of the photos, all of the evidence, all of the chain of custodies for everything. It's more broad where you have to prepare for everything instead of the specified topics. That would be if the attorney did have prior communication with you. Um, this scenario also requires more practice and preparation. Everything must be reviewed. Identifying questions are usually asked first in this scenario. This is the first time usually when you're meeting the attorney, and they ask questions such as, who are you as an expert? What is your relevance to the case? What training have you had that makes you an expert? Or education as well. Any um, classes you've taken, certification, things like that are asked. Once that is established, um, observations, tests, or anything that have been conducted are questioned next. In the case that the expert has not been debriefed, um, like in this case, um, usually visual aids are not admissible, or it's best to not spend their time creating one because it's so broad. There's not really something that can be helpful in that situation unless you prepare for all topics. Um, in this scenario, also, I would recommend reviewing everything and requesting copies of what you can. Sometimes they'll give you a copy of what you had just testified. This allows you to review um, and check to see if there were any mistakes or any errors that you may have possibly opened up to question during cross-examination. Also, I would recommend practice. Once we have gone over preparing for testimony and we're actually testifying, there are some instances that the attorney may object some of the questions that are being asked, whether it be during cross-examination or direct examination. This includes irrelevance, sorry. That means that it has nothing to do with the case or it isn't important. The second is going to be speculation, which means that the opposing counsel is calling for the witness to testify on something that they don't know for a fact, or something that they're not really sure of. Asked and answered as well is a question that may have been asked a few times, but there's just a slight variation and it gets very repetitive. The fourth is going to be hearsay, and that is where they are expecting the witness to testify on something that may not necessarily be true, but they have heard by a third party or anyone else involved. And the last is going to be leading, and that is when either the attorney or the opposing counsel is leading the witness to give a certain answer. And this usually occurs during cross-examination. This During cross-examination, there's both leading and compound questions. Being able to differentiate both types of questions will help you as an expert know how to answer correctly. During compound questions are usually asked to raise an objection because of the witness may be unable to actually answer the question ambiguously, or will confuse either the witness or the trier of fact, and that is according to Huck ETAL 2018. Whereas a leading question is one that suggests an answer. Usually, with a compound question, it cannot be answered with a yes or no, whereas a leading question can. When an expert is asked a compound question, usually they must refrain from answering right away, and they must ask the attorney to break it down. Sometimes they give you a few questions at a time, so you must make sure that each part is being answered correctly and adequately, and this comes from it being broken down and simplified. This allows there to not be any confusion because multiple things are being asked at once. This also avoids the expert from answering questions that they're not really sure of or they may need further clarification. Um, they may also actually review notes or any reports to refresh their memory if you're not sure or if you just have a little bit of doubt and need that little reminder. During a leading question, it is important to note that the expert usually answers it with like a yes or a no, or they don't necessarily have to elaborate, and yes and no is actually an answer in itself. And it is better to say nothing than say too much because that can also um, deem you unfit or as if you don't know a topic if you're saying the wrong thing. According to the textbook Successful Expert Testimony, a few ways that the expert can enhance their testimony is actually the ability to coordinate verbal testimony with documentation. That just means that the testimony can be supported by the documents, for example, the visual aids, the photos, any evidence, any reports, chain of custody. Next, it would be communicating basic and complex ideas in a simple manner. That can be done using like a friend or a family and simplifying, for example, DNA and maternal DNA versus nuclear DNA, being able to simplify that to like a family or friend, and they can give you feedback telling you it's still a little complex, break it down a little bit more, and it'll just help you further explain to the jury or the judge how that actually works. Um, Next, it would be supporting opinions and admitted evidence. This just means that there is a connection between the evidence and the conclusions that have been um, gathered. It just means that there is a link between both of those. And then lastly, a serious but pleasant demeanor. It just means that you don't seem too overeager to answer a question and not uninterested where you seem bored and you don't want to be there. This also helps you seem human enough where the jury wants to connect with you and they trust you and they believe what you're saying, not like a robot or someone that just doesn't want to be there. That's very unpleasant. There's also an observable comfort level with the material and the courtroom experience. This is all according to Huck ETAL 2018, and this just means that it goes back to the initial identifying questions, which means who is the expert, the education, the training, the knowledge, where all of that comes from. During cross-examination, the goal of the opposing counsel is to discredit you, which is where all of that comes from. When they can't really discredit you or your work, they begin to attack you as an expert. They also begin to ask questions that are neither relevant to the case or your expertise to try to intimidate you or throw you off. And the occasion that they do begin to attack your character, it's usually that they're looking for a reaction or they want to throw you off, but just remember that the jury and the judge are watching you, so you do have to be careful with how you present yourself or how you, any facial expressions are seen, and that can give you like either a negative connotation or they might take it the wrong way. So it is important to remain professional, calm, because it can actually backfire on the opposing counsel that asks those questions, make them look bad instead of you. Additionally, the opposing counsel will try to identify any weak points in the testimony or in the science, which will lead to vulnerability. A way that the expert can reduce vulnerability is to maintain control of their emotions, behaviors. Like I stated earlier, during cross-examination, they should be able to trust themselves in their training, in their education, and in their work. As Professor Dan has mentioned, the opposing counsel will attack you as a person and your character when they can't attack the science. And thank you for your time.